Hi, everybody. Today we're here with Representative Kelly Burke. She's a representative from the 36th District in Illinois, and we have her as our guest today because she's going to talk about the 2019 maintenance laws and the modifications that we've had as a result of the modifications of the tax code. So welcome, and I appreciate you coming today.
My pleasure. Thanks for having me.
It's so nice to have the opportunity to talk to somebody who was actually involved in the process. You know, I think a lot of times people come in and they don't even understand how a bill becomes a law. You know, they learned it in junior high, but they forgot it, right? And then when you're talking about appellate decisions in a consultation or you're meeting with a client, they have a little bit of that confusion. So understanding from the inception how that bill changed, I think, is important. So you were one of the sponsors. Can you give us some history of how this bill came about and why it was necessary?
Sure. So maintenance, which many of you might know, formerly know as alimony, more popularly known, is support for a spouse when a divorce takes place. And in the past, there were a couple different ways to give maintenance. And one way was that it made the maintenance payment tax deductible for the person paying it and made it income for the person receiving it. And this generally worked out to be a good approach because the person paying it oftentimes had a higher income tax bracket than the person receiving it. So it worked to spread sort of more money through the family.
Right.
And so we've had this since I think the divorce statutes were written in 1977.
Sure, and then we made a clarification to it.
And then we made
got
a clarification,
the guidelines,
and then we got some guidelines. So this deductible maintenance has been around for a long time. Well, in 2017, on the federal level, the Congress passed a huge tax bill, and one of the changes that they made was that they, for whatever reason, decided that maintenance could not be deductible. So for all cases going forward, anyone who had that tax deductible maintenance can keep it. It's grandfathered in. But for anyone, for cases going forward, starting after January 2019, they can't take maintenance as a deduction. So that's going to change the way maintenance is calculated. So it's not just happening in Illinois. This effort is happening in every state across the U.S. And so a group of folks who work very closely with, divorcing people and the court system got together, had a working group committee structure, and worked through a lot of these changes. And there were a lot of details that they had to work through, a lot of agreements, suggestions, disagreements, and they finally were ready with it for the legislature this spring session. So this past in April or May, one of those times.
Right, and then I think the governor signed it into law in August of
and
this year.
It'll go into effect in January 2019.
So really the guidelines themselves in the sense of how long maintenance would be in place based upon the number of years you were married, that stayed the same, correct?
Yes, exactly.
So, and if for those of you that are listening, depending on the length of the marriage, that can be how long your maintenance can go on for. And under certain circumstances, the court can also review that maintenance in the future. That stayed the same, and then also the other thing that stayed the same was in terms of maintenance and the pot of available income.
Yes.
The recipient of maintenance, including their own income, cannot receive more than 40% of the total net income of the entire pot, correct?
Exactly.
So those two terms didn't modify.
Right.
What modified was the calculation of the guideline itself, correct?
Correct. And so they had to change the percentages to make this all work mathematically.
Right.
Yeah.
And so now instead of 30% of the gross income of the higher wage earner, if I'm correct, what's the new percentage?
33.3% of the annual net income.
Right. So it went from gross to net. So we take that as like the first step. So hypothetically, if you had $100,000 of net income per year, it would be $33,333 if that's the net number.
Minus 25% of the payees, the
Correct.
recipients' annual net income.
Right. So if the recipient's annual net income is $50,000, we'd be subtracting $12,500 from that formula.
So I hope everybody paid attention in math class.
You're going to need it.
You're going to need percentages.
Right. So then it would be under that scenario in our fact situation, 33,333 minus the 12,500. and that would become the maximum amount of maintenance that could be received,
Exactly.
correct? And then the second part of the formula gets employed, which is we take the 50,000 net plus the 100,000 net, and we get a combination of $150,000. So the total available income can't exceed 40% of that number.
Exactly.
So that's how the calculation works.
And I am super impressed that you did not have to rely on the cheat sheets to know all those numbers like I did. So I appreciate Gwen studying ahead.
Well, thank you. The only thing I don't know is what 40% of 150 is, so I should have my calculator here. But rather than me guessing, which I think is $60,000, so if it's 60 and our recipient makes 50, the maintenance would cap out at 10.
Exactly.
So even though the eligibility for the maintenance is higher, the cap gets us a second part of the analysis.
Exactly.
And so that's an interesting calculation. So I think one of the difficulties with the statute is going to be defining what net income is. And I know that we have that for child support, but that is one of the things that we have to look at. You know, to get to net, if you have voluntary retirement, that's not part of your net, right? It's that which is required to get to the net income. And then the other thing that's interesting is it's taxes actually paid. So you can't just walk into your employer and say, hey, why don't you take an extra $200 a week in gross taxes so I can pay less maintenance.
Right.
You know, so there are some levels of protection built into the statute which are necessary. But I think it's going to be interesting to see everybody then arguing over what's the net income.
Right, and I think those will come into play. Obviously, if you're in a situation where you're also calculating child support, the court is taking into consideration those nets. But probably in the situations where it's not a child support case and you're just looking at maintenance, that there might be more.
There might be more controversy, et cetera.
Exactly.
But then we get to the next level is that when you're the recipient of maintenance, so let's walk this all the way through. So you're recipient of maintenance and you have 2 minor children, we take the higher wage earner's net income, deduct what they're going to pay in maintenance. So remember, under a hypothetical, he made or she made $100,000. They're going to pay $10,000 in maintenance, so now they're at $90,000. And then the recipient made 50 net plus 10 of the maintenance is at 60, and we use those new net numbers to calculate our child support.
Exactly.
And so that's interesting. And then what I really want to know about is, interestingly, for the first time we're seeing it in the statute, is that there's a 50% max. So the combination of the maintenance and the child support.
Because that was actually a complaint or an issue that came up once the guideline maintenance came in.
Sure.
That there were, between guideline maintenance and guideline child support, in some circumstances, you had a payor who was paying more than 50% of their income.
And depending on what judge you were before, some of them were imposing that cap because of their interpretation of other laws, and some were not. So that statute clarifies that cap. So that's going to be really interesting, because I think that goes into play as well. So really, though, at the end of the day, think about it from a little different perspective. If recipient of maintenance has 2 children and has the children 80% of the time, and the payor of maintenance has the children 20% of the time, they essentially have the same income structure. Mm-hmm. So it's a question about whether or not that really works out, you know, whether it's fair or not, but the bottom line is that's the nature of what the law is. And as somebody said from the committee, is there's always a scenario under each one of these statutory schemes where we can come out with a calculation and say it's not fair. Right. But as practitioners, what people need to know is there's nothing we can do about it. These are what the laws are, and you can always argue for a deviation from those guidelines as well. And
I think in any statutory scheme like this, where you're trying to create a structure for an extremely broad group of people, there's always going to be an outlier. Or numerous, you know, there's going to be some outliers where the result is not equitable one way or the other, and that's where the discretion and the ability to deviate, I think, is helpful.
Right, and that gives the judges that authority, that ability to look on it on a case-by-case basis. And I also want to be very clear that although the new maintenance law is in place, a lot of times we skip and go directly to the guidelines. And yes, in fact, those are the guidelines. But in order to get there, you also have to look at what's the division of the estate, what are the other factors that get to that payment of the maintenance in the first instance.
Exactly.
So it looks like we're prepared. We're all trying to get computer programs now that are going to be up to date. You know, we all work with family law software, or most people. So getting those new calculations, it's new times. So once again, family law practitioners can't be sleeping. We got to be up, alert, and paying attention to the new calculations.
They are on the cutting edge of developments in the law.
Right, and I appreciate very much that by the spring session, you guys got this done. So you really moved on this quickly to get it introduced and passed.
Yeah, Senator Hastings and I both, did some significant work with our colleagues and talking through it, and the folks from the Illinois State Bar Association did a really good job in presenting it, and I think everybody understood that this was something that was being required under federal law, so they understood we were in a time frame and they were respectful of those time frames.
Right, and to get it done quickly.
Yep.
So we really appreciate it, and it's very good to have a representative who has experience in family law, because that's really an element. Because I think that everybody going through a divorce, they bridge that gap, and when they say,
Sure.
look, this is really based on what Springfield does, so it's nice to have you in that office position to be able to make these informed decisions going forward.
In that experience, dealing with the families and individuals who are going through it, you realize what a difficult time it is for people,
Sure.
and you do realize for the practitioners and the judges that these are a lot of changes that need to be absorbed. So being mindful that everybody's human, everybody only has so many hours in the day, and we need to give them some time to get up to speed.
Very good. Well, we appreciate it so
My
much
pleasure.
that you came out, and it was a good conversation.
Yeah,
I
thanks,
thank
Gwen.
you so much.